Good evening, Crime Talk aficionados. My name is Scott Reisch. This is Crime Talk, the most fact-driven, unbiased true crime channel. Thank you for being patient. Sometimes things come up during the practice of law that needs to be taken care of, and you cannot say, hold on a second, let me call you right back. I have to go do a YouTube show. The legal matter had to take priority, so thank you for being patient. Thank you for waiting for me this evening. For those of you who have never joined us before, my name is Scott Reisch. I'm a practicing attorney here in the state of Colorado. I have practiced primarily criminal defense over the last now 26 years. We do a little civil work, but very minor, maybe 10% of our practice and mostly done by other attorneys. But if it goes to trial, I'll go do it. But when it comes to criminal defense, I have literally handled just about every type of case that you could possibly think about. And so I think I have some very good perspective, hopefully good perspective. Hopefully you all learn something as we go through and talk about the practice of law regarding cases that we've been covering. Now, obviously, we have the Lori Vallow, Chad Daybell matter, and there's supposed to be a hearing tomorrow morning at 9:30 Mountain Time, and it was supposed to be scheduled to discuss basically the motions to compel that primarily Mark Means has filed on behalf of his client, Lori Vallow, basically saying that he has not received all of the discovery in the case. The mean, bad Mr. Wood, is trying to, make life hard, deny his client due process, right to effective assistance to counsel, you name it. He has alleged it. And so far, we've had hearings regarding, listening to attorney-client communications, denied. We've had a hearing regarding Mr. Wood somehow attempting to influence witnesses, tampering with witnesses, just terrible, evil stuff that, prosecutors are supposed to do. Now, trying to be as objective as I can, and don't get me wrong, I'm a criminal defense attorney. I get it. I kind of root for the defense. I really do, because that's what I do. And, I kind of like those impossible situations when everybody's saying, oh, no one can win that case. I'm thinking, give me a shot at it. I will give a run for their money. But in this particular case, when the allegations came out by Mr. Means, alleging misconduct by Mr. Wood, I said, I've seen the transcript of the interview. I see nothing wrong whatsoever. A lot of people have said, hey, Scott, maybe you're a little critical of this Means guy. And I want to say, man, I think the defense is doing a great job. I have said repeatedly in the Lori Vallow case that Mr. Pryor, the attorney for Chad Daybell, I thought he did a very, very good job at the preliminary hearing. He did excellent, in my opinion. All right? We call it the way we see it. There's been some speculation, or some people have said, well, Scott, you just don't like Mr. Means because he doesn't primarily do criminal defense. He is a divorce attorney. He does mediations. So, you're just not being fair. Well, guess what? It's like people who are in a particular field are always going to be more, perhaps, harsh, maybe judge a little bit more, because you know what's expected. You know what's supposed to be done. And so just prior to coming on the show, we were prepared. I mean, I was all prepared. I was here like at 5:30, ready to go. And then the phone rang. And then I had to go take care of something, and that's why I was a little late. So once again, my apologies. Thank you all for sticking here with me. So just prior to us coming on air, what was filed? We already know that Mr. Means, if you watch the video that we put up earlier today, that Mr. Means filed a motion to continue the hearing that was set tomorrow morning because he didn't have it on his calendar. Somehow it was set and he didn't know. Now, in today's world, and I'm not going to say that I know exactly how the electronic filing system works in Idaho, but normally if you're the attorney of record, guess what? You get noticed. You got to check those emails. They come in all the time, but you never know what they are. You got to click on it, save it, print it out, do whatever you're going to do for it. Make sure it gets docketed. If there's deadlines, you got to make sure it gets docketed, right? If you miss those deadlines, what do they call that? Malpractice. That's right. You'll be notifying your malpractice carrier. So in this particular case, Mr. Means filed this motion. It was, I guess I didn't print that one out today, did I? But maybe, nope. He filed a motion basically saying, I'm not prepared, and I want time to file more motions to reconsider regarding the previous motions that I filed that the court's denied when they've said that there's no basis in the law for the court to consider the motion to reconsider. And then tonight, Mr. Means filed an expert disclosure, like one I have never seen before. Okay. Now, when I saw this expert disclosure, it says, comes now the defendant, Lori Noreen Vallow Daybell, by and through attorney, and pursuant to federal rules of criminal, the Idaho Criminal Rules 16, and provides notice of her expert witnesses disclosures as follows. See the attached expert information, expert contact information, accreditations, award publications, etc. Little informal there. But then they say they've engaged or retained Ironwood Insights, and they're expected to testify and offer factual and expert opinions in accordance with the relevant statutes, law, findings, recommendations, opinions, evidence, issues, errors or omissions, ethical issues, legal analysis, culture, etc., regarding all aspects of this case and specifics into scientific survey results of local area regarding the public opinion towards the defendant's pending criminal case. They'll offer reasonable inferences, opinions, scientific surveys, results, and it goes on. And it says the testimony will include the nature and extent of errors, omissions, malpractice, misstatements, incorrect assumptions, unfounded opinions, etc., or the like, and the correlations of said opinions relevant to the motion to transfer the trial. Now, that motions hearing is actually set next month in March. And I get that. But as you go on, now normally when you provide an expert endorsement, and I've just read what they've endorsed, right? I said to myself, this just doesn't seem right. Because under Idaho Rules of 702, which relates to an expert witness, which are nearly identical in just about every state. And it basically says, under 702, a witness who is qualified as an expert by knowledge, skills, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or otherwise specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in the case. Standard 702, right? If you have some sort of specialized training, experience, knowledge, then you can be qualified as an expert witness. Doesn't mean you have to have PhDs. If, somebody's being accused of, an engine falling apart, well, you can qualify the mechanic as an expert. He's got training, skill, knowledge, life experience, and say, this engine fell apart for this particular reason. Okay? Just about anybody can be an expert. There's actually lay opinion testimony permitted under Rule 701, not to get too far into the weeds, but people can testify based upon your lay opinion. Could you tell if the person was intoxicated? Yes, I could. Why do you know that? Because we've all seen intoxicated people, right? Based upon your experience, do you believe that they were going 55 miles an hour or faster? Oh, much faster. Okay, lay opinions. But here's what the expert witness report and disclosure could or should include, all right? And this is under Rule 16. And the first part deals with everything that the prosecution has to turn over, which is basically you got to turn everything over to the defense. And the prosecution gets the same treatment, so to speak, if you're going to use it at trial. And if you're going to use it as at expert hearings, you're supposed to do that. So under expert witnesses, it says, on written request of the prosecuting attorney, the defendant must provide a written summary or report of any testimony that the defense intends to introduce pursuant to Rule 702, 703, or 705 of the Idaho Rules of Evidence at trial or hearing, right? They're going to have a hearing. The summary provided must describe the witness's opinions, the facts and data of those opinions, and the witness's qualifications. Disclosure of expert opinions regarding the mental health must also comply with the requirements of Idaho Code 18207. It says the defense is not required to produce any material not subject to disclosure under subsection H of this rule or any material otherwise protected from the disclosure by the defendant's constitutional rights. Basically what that means, if you can consult an expert, if you have that report, you don't have to turn over unless you are actually going to use them as an expert witness, okay? So jumping back here to the report, we have the disclosure, which I think I've never seen one where they're going to testify to the malpractice, omissions, misstatements, incorrect assumptions, and unfounded opinions. Very bold, very bold. Basically calling the expert witness that the prosecution has as relating to the surveys that they took regarding opinions in the area, basically saying that the other person has committed malpractice. Pretty bold. Frank, the hardest working man in show business, can you put up what was attached? Okay, we're looking this up. Now, normally, like I said, I just read to you what's required under Rule 16 of the Idaho Criminal Rules, right? It was pretty straightforward. You're supposed to provide the report, a summary of what they're going to say, the facts and data of those opinions in which they base those opinions upon, correct? Well, let's look what Mr. Means provided. He provided the company that he had retained, Ironwood Insights. He basically printed off their, what's the word I'm looking for? Their advertising material. Their advertising material. And it's basically, hey, we're a great company. We're a top company. We're going to talk about qualitative methods. Doesn't have anything to do with this case specifically. They've done focus groups, bulletin groups, in-depth interviews, online surveys, data checks, online samples, and they include little things here throughout, but nothing in the form of a summary or an opinion as to why their expert is qualified, what they'll say, and it certainly does not comport to the Idaho rules of procedure, Rule 16, if they want to have an expert testify under 702 for the hearing. Now, maybe I'm just getting a little too into the weeds, maybe, but that's what I would expect. I would expect the attorney to provide the report attached here too as Exhibit A. Please find attached here to Exhibit B the curriculum vitae of our super qualified, mathematician that does all this and has their PhD in statistics and blah, blah, blah. Not the sales material printed off from the website. Now, you could say, hey, Scott, you're just being judgmental. I've never thought of doing that before. Never. Hey, next time, expert, why don't you just send me some promotional material and we'll let the prosecution figure it out. Yeah, I think that would, float about as well as a lead brick, right? It's just not gonna happen. So basically what I'm saying is the trials and tribulations for Mr. Means continues. We will continue to call it the way we see it. It's nothing personal. It's just the way it is. We'll see tomorrow morning at 9:30. I hope to be done with court so that I can be here with you when it starts. But either way, we'll bring it to you, and I will hopefully interject as we go along to see what happens. I haven't seen any orders vacating the hearing for tomorrow, so it should be a go. And it's going to be via Zoom, so Mr. Means can explain to the court why he's not prepared to proceed. And, these really are not that complex of legal arguments that he is making. It's simply, Judge, I don't think everything's been turned over. Please do that. Oh, would you allow me to file a motion to reconsider the denial of my motion to reconsider that was denied of the hearing that we held for some 6 to 8 hours. You heard the evidence, made your findings of facts and conclusions of law, and when those were denied. Somehow I don't think the Honorable Judge Boyce is going to change his mind. We've talked about this. Judges don't change their mind unless they completely miss something, completely misread the law, or there's some new evidence that was not available at the time of the hearing. You had your shot. All right. So thank you. That's quite a lengthy introduction that we had there regarding the Means, Mr. Means, regarding the Lori Vallow case and the motions hearing for tomorrow. Like I said, he filed a motion to continue saying, basically, I'm not available. I'm not prepared. This notice that you sent out about 25 days ago somehow didn't make it to my calendar. And even though the co-defendants counsel apparently shares office with me, at some point, I never realized that there was a hearing set for February 17th. So, Judge, please let's continue this so that I can file more paperwork that you're going to deny. Like I said, we do civil work. Civil work is a different animal, okay? Rarely do you go to court in civil work. It depends on jurisdictions, but it's all done on the paper. You file it in the paper, you plead it in the paper, and judges rule on it, on the paper. That's what they call it. They're going to rule on the paper. Rarely do they set much for court unless it's discovery issues or an actual trial. And so by the time, you get to trial, all that should be hammered out. But in the criminal world, you show up and here's the issue, Judge. Let's argue it. One of my pet peeves is I have to file motions. All right. And you would think the prosecution would have to file a response, and then I get to file a reply. Now, in federal court, the judges hold the United States attorneys to that standard. I file a motion. They have 14 days to respond. Once they file that, I have 7 days in which to file my reply, if any is warranted. In state court, what drives me nuts is I file my motions, I do the research, the district attorney shows up and I don't have everything, but I got a witness. Can we just put them on the stand? Why not make them spend hours writing these wonderful briefs and motions? They're so busy, they don't have time to do it. Exactly. And if they did have time to do it, maybe they'd look at some of these cases sometimes and say, man, this is a piece of crap case. I can't prove this. But they don't. So bottom line is that's just kind of the way it is. So in the criminal world versus the civil world, you're in court. You have to be able to think on your feet, have your argument ready to go. Normally when you go into a criminal courtroom, you got 20 cases sitting behind you of other attorneys that want to get their case heard. They're usually double set and they want to get going. So you're very focused, succinct. Brevity is always appreciated by everyone. Oftentimes I've said this in meetings lots of times, when we start repeating ourselves, that's when it's time to end the meeting because we're repeating ourselves. We've heard it once. We don't need to hear it again as it relates to that particular same day. Same thing when you go to court. Okay? All right. Thank you. So we have a super chat up here, and we always appreciate super chats. We don't beg and grovel for super chats, but I've seen some channels that do. Appreciate it. It certainly helps make your question stand out. So this super chat is from Shadow. Can Lori later use poor representation of means as a to get a new trial later on. Pretty unlikely. Okay. When a defendant hires their attorney, obviously you hope that they're qualified, or if they haven't done a lot of work in that area, that they spend a lot of time really boning up on the law, getting up to speed so that they know what they're doing. And sometimes, think about it, like in flying, when are you the safest? Right after you come out of your training, the longer you do it, sometimes maybe you get, you think, oh, I've done this before, but you always got to go back and, read those statutes and stay up on things. Now, one could argue that, hey, Lori Vallow picked her poison. She picked her attorney. She could have gone with the public defender. She could have hired anyone that she wanted, or anyone that Chad Daybell maybe wanted to hire, and she chose him. She's been aware of what's going on in the case. He has to let her know what's going on in the case. He can't not say, hey, by the way, every motion we filed, we've lost. You can't do that. So if she has concerns about her attorney, she needs to make that pre-trial more than likely, because just because you lose doesn't make you ineffective. Okay. Now, have I agreed with every move that Mr. Means has made in this particular case? I think the one I agreed with was that he waived the preliminary hearing, because Mr. Pryor did such a good job. Why do you want to mess up any of those individuals that you were able to lock into your statements? Okay. So that's, I think he did a good decision there. There was one other one. I think it had to do with, I can't remember, but I definitely know it was, he did it. I said, yep, made the right choice, waiving his preliminary hearing. He wasn't going to get anything out of it. The case isn't going away. So at the end of the day let's say Lori Vallow loses. She's going to have to do her appeal. Then she would go and do her post-conviction relief. She would not be precluded from filing a claim of ineffective assistance of counsel if she were to lose at the trial court level, and if she was denied any relief at the appellate level, assuming she lost. We're obviously giving her the presumption of innocence. We'll see how things go. But she wouldn't be precluded from saying, poor attorney. But one could certainly say, hey, you picked him, you trusted him, and you never know. Maybe he'll absolutely surprise us at trial, just hit it out of the park. You just never know. But maybe he just doesn't have the time, the resources to do this. I mean, I don't know what he's getting paid, if he's gone through the retainer, if he's sticking it out, what their financial arrangement is. But, this is a case with a ton of electronic data that's been produced pursuant to the disclosures that we've seen. Phone downloads from numerous people. I think the other day we saw it's 2, 4, 6, 8, 10, at least 12 people, plus all the other data, GPS data. I mean, it's a ton of stuff. It takes time to go through and focus. And when you're handling a bunch of other cases, this, you need to have a staff that can help you with this. Frankly, makes it more efficient for an attorney to have a paralegal or somebody, an associate, do these types of things. But if you're a one-man show, that's real tough when you're still trying to run a law practice and handling the biggest case of your career, keep your other clients happy. So who knows? But those are all issues. We'll have to wait and see, how things go at trial and if there's getting relief. But, if someone's going to make a change in attorneys, they better do it sooner rather than later. You don't do it the week before trial and say, I don't like my attorney. He wants to withdraw because he hasn't been paid. You need to do that early on in the case. And sometimes you do your client a disservice. Sometimes a client simply cannot afford a private case. And I would submit to you that most people in a case like this, which could literally be a full-time job between now and the trial date, couldn't afford the attorney, couldn't afford the staff, couldn't afford the expert witnesses. That's just the way it is. Most people do not have the resources. Think about it. If you're working, let's just say 8 hours a day, let's just say you're billing $400 an hour. That's $3,200 a day times 5 days, but you're probably working 6. So 6 times 3, 18. You're looking at, potentially $20,000 a week in attorney's fees for one attorney. What if you have multiple attorneys? Most people, unless you're independently wealthy, maybe you own your own business or something, cannot afford to pay attorneys. It's just too expensive, let alone when you have no resources. I mean, from what we've known, I think it's pretty clear Lori Vallow didn't have really a pot to piss in when she started this little adventure. Chad Daybell had, from what we can tell, a house, and it looks like, and if whether the documents are correct, that it's been a lien has been put on it for legal fees, but I'm sure that'll get sorted out at some point. But it simply shows that whatever cash on hand was not simply enough to get you through the day. And you're going to have, a 3-week trial? Okay? Even if you're in court 8 hours a day, people do not get it. When you get done with that 8-hour day, you're probably going to go back and work 6 hours that night, 4 hours. Hopefully you've done a lot of prep beforehand, but things change. Yeah, you're ready, but then you get into court and a trial is constantly changing and flowing. You may have the greatest cross-examination, but somebody said one thing on the stand, and now you got to go rework the whole examination because, hey, you think the jurors are really interested in this way, so let me go rework that and make sure I have it all ready to go. So, it's just, like I said, most people simply do not have the resources to do that. And sometimes you're doing a client a disservice. Sometimes you have to tell a client, I would love to represent you, but you don't have the financial means and resources to do this case correctly. Therefore, I'm not going to take the case. You should go with the public defender. If there's a conflict, they'll appoint you a private attorney to represent you. Just because it's the right thing to do. Because guess what? If you go to trial and you didn't hire the experts and they could have made a difference, then yes, that will be a claim on an ineffective assistance of counsel. You got to really kind of document that, saying, hey, we're making a tactical decision as to we're not going to retain this expert. Understand you can't afford an expert, but we really, really need one. So, we'll just have to wait and see. All right, Shadow, is he getting paid by the word? That was very difficult to read, let alone understand. Where's he going with whatever that was? I don't know how he's getting paid. I have no idea. I don't know if it's a flat fee. I don't know if he's billing by the hour. But a big case like this, unless you're billing by the hour, you're losing money. So let's see here. I think I saw another chat. Let's see here. We're going to stream the George Floyd hearing. The trial, that was my intent to do the trial. Not sure we have any hearings. I have to look at that schedule for any live hearings that are coming up. Let me see here. I thought I had another super chat go by here. So let me see if I can find that. If not, we'll go back to the top. Oh, there it was. Let's see here. Shadow. And I don't know anything about this, whether it's true or not. Heard about a neighbor of Chad's. He died a few days after JJ. A man always walked around Chad's property lines, died of the same illness as Alex. You never know. Lots of coincidence out there in the world. Certainly makes good conversation, good speculation, but I don't know. I haven't heard anything or read anything about that at all. Let's see here. All right. Let me go back here to answer some more of the questions. All right. So hopefully that explains kind of what's going on. I'm certainly going to be watching tomorrow at 9:30. My gut feeling is the court will say, Mr. Means, I'm a little surprised that you aren't prepared, that you weren't aware of this date, particularly since your co-counsel is in the same office. We have proof that it was sent out to you and then for you to file a motion and want to file more stuff. I just don't think that they are going to continue it. I think the court's going to say, we need to move this case along. Let's do this. It's set for the motion to compel. And the government has filed their response to all of the issues that Mr. Means said he has not been aware of or been provided, and obviously the whole cell phone issue. I really want to see the cell phone issue. I do not know under what legal theory that any judge would say, under what authority do I have the ability to tell the jail how to run their jail so that you can communicate with your client? We talked about that motion as well in a previous video that we did. And, he showed photographs that he had to talk to his client via the glass window and he had to use a phone. Okay. Welcome to the jail. I've literally sat in little broom closets where I could barely get in. You couldn't fit two attorneys on one side. You had to pass the documents through. Sometimes I've had clients that have been handcuffed on the other side, and you ask the correctional officer, can you uncuff him? And they're like, no, sir, we cannot. So they have to, sign the paperwork with their hands handcuffed up like this. That's just the reality you're dealt with. And, you can, complain and go to the judge, it's not conducive to it. But the judge has no authority to say, you need to provide a better space so that this can be done. Certainly the judges in jail, I've never seen anyone intentionally be, and I'm sure it's happened, but I've never been refused access to my client. And my experience has always been, if you're nice to the people at the jail, usually it's sheriffs or Department of Corrections people, usually if you're nice to them, and if you say, hey, this isn't going to work, or we're going to be here a really long time, is there somewhere else where we could move? They usually try to accommodate you. But the jail that Lori Vallow's at, remember, Mark Means accused them of listening in on telephone calls early on. He tried to say they were the worst, most heinous people in the entire state of Idaho. How dare they try to interfere with he and his client communicating? Wow. I wonder why these people are not going out of their way to try and accommodate him to do that. And I'm not saying you need to be a complete kiss ass to the people at the jail, but you just have to be nice. You have to be respectful, right? Most situations you're in life, what do you get? If you're respectful to the other party, they're hopefully going to treat you with dignity and respect as well. That goes a long way. But when you go in there, and sometimes you have to, but if you go in there poking fingers in people's eyes, figuratively, obviously, what's their incentive to accommodate situations that maybe aren't the best? Maybe they could change, but they're not going to, because for lack of a better term, you've just been a complete ass, right? They're not going to do it. One of the declarations that Mr. Pryor filed saying, hey, my client's at this other jail, and they've been absolutely nice. We haven't had any problems whatsoever. They've been very accommodating to everything that we've requested and everything I've asked for. Somehow I think Mr. Pryor has gone in there and knows the people at the jail, or at least knows how to be professional and polite. most people in life will want to help you unless you're being a complete ass to them. It's just simple. If somebody thinks I'm being wrong about that, put it in the comments. Let me know. But you got to be nice. I mean, these are the things that they do not teach you in law school. In law school, they teach you just enough law to be dangerous. When you take the bar exam, you've proven that you know just enough law to be dangerous. When you're in law school, they have you, you're going to write a brief to the United States Supreme Court. Okay. Because that happens all the time, right? No, it doesn't. They should literally have classes in law school about how you're going to treat the court staff. Always politely and respectfully, you're going to treat them, even if they're being a jerk to you. Maybe they're just having a bad day because there's 80 people on the docket and they're printing something out, and you come up and ask a question like, why can't I get my case moved up? And he's like, take a seat. And you're like, oh, I'm sorry. I didn't realize. Sorry. You got to be nice, okay? Same thing with the attorneys, district attorneys. When you're dealing with the district attorneys, I can count on one hand the district attorneys that I usually cannot get along with. And I'd like to think that it's probably something that they did, but maybe it was me. But there's some people you just can't trust. You always put it in writing. You do not trust them. But for the most part, let's face it, they're going to be there for a while, well beyond this particular case. And I'm not saying you're not going to do everything you can to zealously represent your client. And if they do something wrong or unethical, you're going to call them on it. But for the most part, they're doing their job. What motive do they usually have to intentionally try to screw your client over? They usually don't. They're going to be there long after this client, whether he takes the deal, goes to trial. You're going to have to deal with that staff, those district attorneys. You can be nice to them, right? Even if you don't like them, you still got to be nice to them because there's going to be that other case. But the thing that you're going to want to have is your reputation. Your reputation of saying, hey, you know what? Scott's a reasonable guy. He's zealously representing his client. He's going to keep asking for what his client wants. I'm going to keep saying no, but we're going to do it respectfully. I engaged in several of those emails and conversations today. When the district attorney says, hey, I appreciate your advocacy for your client, but I'm not changing my mind. I get it. I tried, right? But I'm not going to, throw monitors. I'm not going to say, oh, you're being a jerk. You don't. No, you have to be a professional. Yelling at them, calling them names, anybody named, is not going to get you to that next level where they're going to say, hey, that guy's a straight shooter. And you know what? He usually comes to me and he's being reasonable and saying, hey, you charged my client with this charge. Don't really think you can prove that. You can probably get this, but since my guy's accepting responsibility, not making you have to do a whole lot of work in your case, why don't we go maybe one count even lower, felony charging lower, and everybody's happy. It's like, okay, fine. Or when you come to a district attorney and says, hey, I have a real issue here. And they say, you know what, Scott? Wow, you usually don't come to me. You don't file all the generic boilerplate motions every time. You're not always up there being that guy accusing me of misconduct. And you're telling me you got a real issue here? I better take a look at it. And they'll say, oh, I think you can either get around that, or I think you're wrong, or, hey, I think you got an issue. You're right. Let me make you an offer on this case because I don't want to have to litigate this and potentially lose. And there's no guarantees. Your motions issue in front of a judge is only as good as the judge that you were in front of. Okay? I've lost lots of motions hearings over the years where I should have won. I was correct. The facts came out just like the law said they should have been applied, and I lost. Because your motions hearing is only as good as the judge that you're in front of. And let's face it, there's some judges that are never going to grant your motion to suppress the evidence that's going to let the bad guy go away. He's like, I won't admit that evidence when the appellate court tells me you shouldn't have admitted it, and I will not admit it on the new trial. but they're not going to do that. Very few judges are that bold where they're going to do it. And you'd be surprised. You would think most judges would be like, man, the governor or the people have appointed me, elected me. Here I am. I've been appointed for my independent judgment. I've been here to make these hard decisions, to apply the facts to the law, to be neutral, completely impartial. Just call balls and strikes. Doesn't matter whose side you're on. I'm just calling balls and strikes, just like a good umpire. Very few of those judges truly around. Most of them are in federal court. Why? Because they got a job for life and they truly love the law. They're not just there to get their retirement. They're truly there for the love of the law. And they call it the way they see it. They're not going to give favoritism to any one side. That's all you want, right? Fair trial, end of the day, bottom line. All right. Excuse me, so thirsty today. Let's go back to some of these questions here. All right, Frank, the hardest working man. Julie, have you seen any great questions that I have missed that like, you know, the market means incompetence. I think I got all the super chats there. Oh, yeah. Oh, look at the weather. Kelly's saying -10 here in Texas. Canada, please take your weather back. Absolutely. Everyone is being hit by this terrible, terrible cold front. I hate the cold. I hate the cold. I hate the cold.
Good question on Facebook. If
Okay.
Mr. Means runs out of resources, can he quit?
Oh, good question. That came in on the Facebook chat, which I don't have right in front of me. But the question is if the money runs out, and I'm paraphrasing, can he quit? Yes, he can. Now, every attorney, whether it's a civil or a criminal case, once you enter your appearance, you are on the case until its resolution by the court. You know, like if somebody pleads guilty or you go to trial, and then, you know, it depends on your arrangements for appellate issues or things like that. But the bottom line is you have to remain on the case until you are either fired by the client or relieved by the court. And you have to then basically file a motion for leave to say, Your Honor, I need to move to withdraw. All right. Who here, let's have a show of hands. Who here has ever seen The Lincoln Lawyer? Okay. Great movie. You know, they took a little artistic license with some of it. But for the most part, you know, I think the guy says, he gets up, he says, Your Honor, we need to continue this motions hearing. We're looking for an essential witness called Mr. Green. Okay. And the judge's like, oh, okay, got it. Motion continue granted. And the client's like, what the hell, man? Like, I was ready to go to trial. Ooh, that essential part of the case called payment isn't here, right? That's why defense attorneys, most attorneys, when you go to trial, you like to get all your money up front because, you know, whether you win or lose, more than likely someone's going to try not to pay your bill. Very frustrating. Very, very frustrating for sure. Thank you for the super chat there, Chasing a Murderer. So, I mean, that's kind of a good example. Can that happen? Sure. I personally don't like to file motions like that. I like to, frankly, let's go to trial. You know, I try to get my money up front. Everybody knows what the fees are going to be, the appropriate retainer. So let's go do it. But I have had cases where I said, hey, listen, this is going to be a 3-week trial. I'm going to need 2 experts that are probably going to require payments of review for one payment, drafting a report for another payment. And oh, by the way, you are going to have to pay him, you know, for trial as well. So let's say, you know, the expert's costing you $10,000 each time, $30,000. You need that expert, right? And let me give you the example of an expert witness that I once flew down to see. I'm there with my investigator. We're there. We're going to meet him. We're going to go over all this stuff. And he's like, hey, pleasure to meet you. got my check. Before he would sit down to talk about the case, he's like, you got my check? And of course I was like, I told you I'd bring it, right? And he's, that happens throughout the entire process. People don't like to work for free. Raise a show of hands. Who likes to work for free? Yeah, not me. Not me. Most people don't want to do that. Could you imagine if you went to work and said, hey, I'm not going to pay you this week. The boss says, I'm not going to pay you this week. It's not a big deal. I mean, it's working for free, right? And that's just the way it is, right? So you have to be able to do that. And so if the client can't afford it, you basically you got to get off the case, but you can't get off until the court tells you to. Now, can the court keep somebody on? Let's say, hypothetically speaking, Mr. Mean says, wow, I'm going to have to do a 3-week trial. And, if I was back in the office, I'd be making, $15,000 a week, and I'm going to have to prepare. I don't know if you have enough money for this. And they say, hey, all the money's gone. If you win and I can get out, I can start making payments for you, like $100 a week or a month. And you're like, that's not acceptable. And if I lose, what do I get then? When you get out of prison in 10 years, it's not like you can ethically take the movie rights, right? So what do? You have to ask for permission to get off the case. Can the court say, no, you're not getting off the case? Yeah, I've seen it happen. Now, most trials, if it's a 1-2 day trial, you're going to hope you do a good job, get a good verdict you want, and the guy's going to continue to pay you. If not, you got to go chase him down for the money. And you're not going to say, hey, judge, I'm getting off, because you don't want that reputation. But on a big trial that's going to go on for weeks and weeks and weeks, hey, you have a right to be paid. The judge can't force you to work for free, indentured servitude. They could, but more than likely, that's the kind of situation where you lean over your client and say, I'm not saying I've ever done this because I never would, but think about it. You lean over to the client and say, wow, so you're going to trial with the guy who's not getting paid. Now, I've been in that situation where I think I'm never going to get my money, but I'd like to win. I like to do a good job. So even if I wasn't getting paid, I'm still going to go out there and try and win and do absolutely the best I can. But I know there's some attorneys like, man, dude's not paying me. They have people that have been found to be effective assistance of counsel in death penalty cases that fell asleep. And that was competent legal representation. So I think I'll just sit here and I'm not going to do much of anything. And that'll just be a good tactical decision. Yep, that's it. So I don't know. Like I said, if anyone in this particular case is going to try and do that, I think the judge's head would explode. Yes, COVID has already come into effect in this particular case, but you can't make a guy work for free. But if you're going to do it, the closer you get to trial, the more likely the judge is going to make you work for free. Bottom line. Mama Pink, I cleaned my attorney's house and office for a year to pay for my divorce. Yeah, and that's what people do. I mean, I've had people over the years like, hey man, case is over, did a great job, I want to pay you, I just don't have everything. All I have is this car. Oh, well, I don't know. Well, what kind of car do you have? I'll take it. I want to get paid. I want something. Attorneys used to barter. You see a lot more of that. I won't take stuff beforehand, but if we're all resolved, case is over, client's happy, they want to pay me with something, I'll certainly consider it. But yeah. I'm trying to look here at some of these questions here. What does Lori gain from Mr. Means as her attorney? She has to know by now that he's not capable of giving her the best defense. So why does she keep him around? Who knows? Maybe she trusts him. I don't know. I think that's one of the most important things that you can, when you're considering hiring an attorney, is you want to hire somebody that you feel comfortable with, that you can, in fact, trust the person. I mean, they're going to be giving you legal advice that's going to affect your potential liberty in the case. You're going to want to have somebody that you trust. And who knows, maybe they got it. It's like, hey, he's saying, just do whatever you can. This is the money you got. Just do whatever. I'm just going to sit over here, not going to testify. You just go do that lawyer stuff, and we'll see how things turn out in the end. So you just never know. Everybody loves their attorney until you lose. I don't know if I've ever told this story. And I'm not doing, because some people said, oh, Scott, all you want to do is talk about yourself. No, but I think if I can provide an example of something that I've seen in the legal profession, it may help explain what, happens in the attorney-client dynamic. Had a case once, a client, we'll just refer to them as client A, and this client was very aggressive. The client was not going to take a deal. We were going to trial. Okay, that's what we do. We go to trial. I thought things were actually going quite well. But at one point, the client looks over at me and says, oh, it was in closing argument. The prosecutor got up and did her closing argument, the first closing. And the client leans over and says, I'm getting up and walking out. You have lost this trial, and we're going to lose. She's a much better attorney than you are. I was like, okay, but I haven't even got up from my closing yet. So, sit down, shut up, and let me do my job. I get up and do my closing, and client says, oh my God, we're going to lose. You're terrible. I'm getting up and walking out. This is ridiculous. I'm like, sit down. You're not walking out. Jury comes back not guilty to every count. Okay? Am I bragging? I don't know. I'm just telling you what happened. And the client then was like, oh my God, Scott, you're the best. I'm so sorry. You were the best. I'm sorry I ever doubted you. I was just scared, blah, blah, blah. Okay, fine. Thanks. We'll send you a final bill. And that was the one client where this client got in trouble again, and the other attorney called and said, hey, client A really wants you back. You did such a great job. Would you help us? I was like, literally $1 million for a retainer. And the other attorney laughed on the other side. I'm like, no, I'm serious. $1 million. I said, that's how bad client A was to work with, to deal with. Not going to do it. But it shows one day you're the greatest thing since sliced bread. Next second, you're the biggest bag of trash. I mean, I've had clients say, oh my God, man, I've had lawyers before. Scott, you're the best. I've never seen anything like you before. And the verdict comes back and you beat the big counts and you get convicted. They get convicted on something else. You're like, I kind of told you were going to get convicted on that. That's what I kind of told you to take the deal, where this is probably where we're going to wind up. And they're like, you're fired. You suck. You're the biggest bag of trash ever. Okay, fine with me. That means I don't have to do the paperwork for the appeal. But that's the way it goes. It's a love-hate business. Some days your stock is high. You're getting referrals from the jail all the time. You're the best. And then your stock is low. Oh, yeah, I heard about you, man. I've been checking up on you out here at jail. Some people don't like you. Oh, yeah, who? Oh, yeah, that guy. I can't go into specifics, but you may want to ask him about the facts because I can't disclose that. But you may want to ask him. You know what I mean? And then they're like, yeah, you're cool. So it's just the way it is, and it is a love-hate business. Who knows what means in Vallow, what the arrangement, who knows? Let's see, Kaylee, I worked for an attorney who didn't collect her debts. It affected her livelihood and mine. Our clients owed her over $50K before she finally petitioned to remove herself as counsel. Yeah, people just don't realize how much time goes into a case, even a simple case. People think, how tough could it be? Well, if it were easy and all the facts were in the defendant's favor, we probably wouldn't be here because there would be no case. So clearly they must have something to put your liberty in jeopardy, right? I wasn't there at the facts. I'm not the one that created the facts that have brought us all here together. It may take me a little time to kind of unwind it. Bottom line. Bottom line. Yeah, I mean, if she were to withdraw, unless she has lots of money, if there's a GoFundMe page or something along those lines, she would get the public defender's office. And frankly, public defenders, that's what they do. Some people are like, oh man, I'd never have a public defender. Some of the best attorneys I've ever seen have been public defenders. Just like some of the worst attorneys I've ever seen have been private attorneys. It just depends. I want an attorney that wants to win at everything in life. Everything is a competition. He is going to win or she is going to win. That's what drives them ethically, playing within the rules. That's who you want as your attorney. Somebody that's like, I don't care. You're not going to outwork me. We're going to do everything we can. You may win, prosecutor, but I'm going to make you crawl over glass to get there. All right. Let's see here. All right. Catherine, have you ever done any pro bono cases? What sort of case would move you to work pro bono? Great question, Catherine. Do I do pro bono cases? Not much anymore. I have clients that, they ran out of resources and I will finish the case up. As far as I'm concerned, that's pro bono. But to do a case pro bono, you have to treat it as though you are being paid and that basically somebody has said, we are, the money's no object. Right? Because if you need an expert, you do a pro bono. Does that mean you're going to go hire this expert pro bono? I don't know. Maybe perhaps on a 35C, if I was convinced that, someone was truly innocent, I would probably do that. But pro bono cases do not pay the bills. That's just the way it is. Because at the end of the day, it's a business. You have to pay your staff. The guy that dropped that copier off, he wants to get paid every month. The IT guy wants to get his service agreement every month. You have a business to run. Maybe if I won the Powerball, if we had a huge civil case that settled for tens of millions of dollars, then maybe, yes, I would go do that. But these cases take time. And unless you just have a pot of gold that you don't need to tap into, or you can tap into it, and so it's not an issue. Pro bono cases are, they're tough work. I've known people that have done pro bono work that have gotten grieved. My general experience is people appreciate something when they actually pay for it, work for it, versus giving it for free. Now, there's lots of people that do lots of good pro bono work. My hat's off to them. I have just been burned every time I've done a pro bono case where things did not exactly turn out to be exactly the way they were represented. And then once I was in the case, I couldn't get out, and I had to fork out a lot of money to make sure the case was done right, to protect myself, to make sure that I didn't get a grievance, that I didn't get an ineffective assistance of counsel claim. So, I was basically the equivalent of a public defender when I was in the Marine Corps. Yes, I got paid, but I didn't get paid that much considering the amount of cases that I had. So I kind of consider that my pro bono work, and not to mention all the people that haven't paid me. I know that probably sounds bad, but hey, we're telling you like it is. Everybody, there's so many people that went to law school to save the world, which is a noble idea, but you can't save the world unless you can live as well. And I've seen a lot, mostly mass tort attorneys, the ones that have won the big cases, billions of dollars. Those guys do incredible, incredible work because they took the risk. But you don't realize how much of a deep pocket you must have to do these cases, right? I'm telling you, we do personal injury cases. We've got some big cases, and they're expensive. And I may not get paid for years, if ever. But the guys that win those big cases, they do a lot of good because they then go out and help more people because they take them not pro bono, but on a contingency fee basis. Think about most people that are injured in a car accident, right? Oh my gosh, an ambulance chaser, a contingency. You don't get paid unless we do. Absolutely. Most people couldn't afford to go hire an attorney. If said, hey, wow, this case, you got a lot of injuries. I'm going to spend hundreds of hours going through medical records. I'm going to need a $50,000 retainer for this. Most people don't have that. They're not going to do it. So I'm a fan of people that have done those cases, won the big cases, and they give back tremendously. You can do more good if you have the financial resources to do it. Bottom line, right? Like I said, everybody wants to go to law school and change the world. But you need the financial means and resources to do that. Litigation isn't free. Hell, you file a civil case, they charge you $450, I think is what it is right now. And you filing those a couple times a week, starts adding up. And if you're eating the bill, that adds up real darn quick. So let's see here. A lot of people have divorce attorney experiences that they're talking about. Their lawyers here. Blix 74. Scott, as a Marine, you're a rifleman first. What's your rating? Well, I was an enlisted guy. Got out, honorably discharged as a sergeant. I was an 0861, a scout observer for an artillery unit. Then I went back in and I was a 4402, which was an attorney, judge advocate in the Marine Corps. And the difference between all the attorneys in the military from the Marine Corps and everybody else, everybody in the Marine Corps is a line officer, which means they could say, hey, captain, lieutenant, you're now an infantry platoon captain, CO, go. Because every Marine is a rifleman. Every Marine Corps officer is a platoon commander. Adam, Scott, quit crying. Wah. Get deeper pockets and do more pro bono. The next one will turn out great, I promise. I hope so. I do. We got some civil cases that are if things go great, it could be a very good situation. If they don't turn out great, it could be a very expensive gamble. But what can you do? You got to do it because it's the right thing to do, right? That's why we're taking that. We believe in the client. We believe in their case.
There's a super chat asking if you have to.
Let's see. Did I miss a super chat? Let's see here. Let me go back. See, I'm learning. Jennifer, do you have a son? Yes, I do. And although he's a little private about his dating life, he's single. He was in a serious relationship. She too was a pilot in the Air Force. and then they broke up. So he's available. There he is. He's 26. That was when he flew down one day, and he got to do some bombing runs on this. This is an airplane that the Air Force trains pilots from other countries to do. It's kind of a light thing, so he got to go do some bombing runs, and but he's going to be real busy because he's transitioning airplanes here real quick. He'll be heading off to fly F-16s. But yeah, he's a catch. Seriously. Not just because I'm his dad. I've got a daughter too. All those great guys out there that would like to date my daughter, let me know. We can try to work something out. She's a nurse practitioner, 24. I mean, she went through grad school just like that. Nurse practitioner. So anyone that, has, someone comes from good stock, you all let me know. Okay. We'll take care of it. Kelly, our attorneys all have court-appointed cases. I don't know where you're from, Kelly, but here, and we still take court-appointed cases. My firm does. I do. I take more of the big stuff, usually murders, homicides, stuff like that. So yeah, it's and that's, I guess, my kind of way of giving back. I mean, it's not worth, I don't get what I get paid in my hourly fee, but it's kind of my way of making sure that I think people are getting good legal representation. Scott, can't you send them a bill for the remaining amount that your client owes you? Oh, yes, but try getting paid. And what's being grieved? That's when somebody goes to the Bar Association and says, my attorney didn't do what he said he could do, which is why I make no promises or guarantees as to specific outcome or representation of how the case is going to turn out. So, yeah. And then it goes to the grievance people, which is basically run by the Supreme Court. It's the Bar Association, and they would decide if you did something wrong. Most attorneys, you have to, anybody can grieve anybody. They can do anything they want. But the what's the word I'm looking for? Most of them are frivolous. But, the general rule is you don't steal your client's money. Don't sleep with your clients, and keep them informed. Be a competent attorney. Be a professional, and you're going to be okay. That's the general rule. And that's where most people get grieved, is they steal the client's money. You hear about the lawyers that get disbarred. Oh, they had a big settlement that came in, and they never paid the client. Look at Michael Avenatti, who's the other guy in LA right now. Married to the Beverly Housewives, real famous attorney, did big mass tort stuff. People were claiming that he didn't pay them when their settlements came in. Scott, you were a JAG. Yes, great experience. It was a great experience. Totally sink or swim, because you show up your duty station like, all right, here's your files. You got 3 trials next week. Couple of plea agreements, go forth and do great things. I mean, you're either going to do well or crash and burn pretty quickly. That's the kind of environment where you figure out, hey, I really love being a trial attorney, or yeah, I'd like to do something a little slower pace, a little less stress. But it was great experience. Do you ever feel threatened by your clients or worry about your safety? Not really, no. Most of them are harmless. And, hey, I'm trying to help them. Why do they want to harm me? I mean, I've told stories where I've had, usually it's in homicide cases where the victims' families make people feel uncomfortable. But I get it. Usually just talk to the DA and tell them to stop it, be nice. I'm just doing my job. Let's see here. I can't believe that anybody says anything nasty about your stories. Oh, yeah. Listen, one thing I have learned since starting this channel, we're at 2 years now, 2.5 years, I guess.
Yeah, around that.
about 2.5 years. At first, I'd put a video up, and I would read absolutely every comment. I still look at just about all the comments, but it would be like, this guy paused too much. He said, or he said, like. He can't talk, whatever. He mispronounced a word. Somebody would be like, his tie sucks. And I would take it very personal. Like, really? And it never really used to bother me, particularly because I'm a defense attorney. I walk into a courtroom, the jury, people may not like me or not, but I got to do what I got to do. And now what I have realized is no matter what you say, how you say it, somebody is not going to like it. And it doesn't bother me. I've called a couple people out. I mean, somebody says, why do you say this? Hey, tell me where I'm wrong. Tell me where I'm wrong. If I'm wrong, I will say I'm wrong. Okay, wasn't aware of that. Maybe new facts came about. But some people, it is what it is. Like I said, I'm pretty much used to it now, particularly on here. No matter what you do, what you say, somebody's going to be upset. Oh, you mispronounced this. My personal favorite was when I referred to a victim who was a young lady. She was like 12. And somebody said, she's a child. How dare you call her a young lady? Oh my God, you're the worst person in the world, Scott. And I'm thinking to myself, if I had called my daughter at 12 a child, she would have looked at me and said, Dad, I am not a child. I am a young lady, right? So I was trying to be courteous to the victim. I said, this young lady, she stepped up, she did the right things. But I got more grief out of saying young lady. People are like, I can't believe he said child. She is 12 years old. She is a child. Okay. And I went and explained myself on the next day. I think I explained in the chats, and people are like, well, okay, fine. But, wow, really? So between what I say, what I get comments about, or YouTube, our video, I don't even know. Did the video we get up today, Frank, did it get monetized at all?
Let me check.
Not yet.
Not yet, no.
The video today we put up, not monetized. The video we put up yesterday, not monetized.
The video on Friday.
Please, Friday. Was it Friday? No, Monday. No, Monday.
Monday. Yeah.
Monday. We put up stuff on Monday. Tell me, please, tell me the stories we talked about on Monday, because today's only Tuesday. What is so shocking, the content in there? We talked about the Vallow, the procedural things. We had one or two stories. One was about the young kid that defended himself, and that's the only thing I can think of. So a story that can be talked about on the evening news can't be talked about on YouTube, because YouTube has decided it's too sensitive of a subject, and you all, aren't adults, and sponsors can't decide if they want to, engage in, a channel that caters to people over the age of 18. I don't get it. Okay, SG, Super Chat. Green, California attorney here. You should read up on, if you haven't already, and discuss the legal battle between the LA DA, Gascon, and his deputies, DAs. That is actually very interesting, because the DAs are actually suing him, and I didn't even know the DAs could have a union, but apparently there's so many DAs in LA County that they have their own union. Anyway, they were going to sue the DA, basically saying you can't violate this policy because it goes against the law, which I'm all for that. That makes complete sense. Their policy saying we're not going to enforce the law. Yeah, you have some sort of prosecutorial discretion, but you can't just ignore the law. So anyway. And then Sylvia, thank you for your super chat. Thank you. We got started a little late today because sometimes things come up in the practice of law. And young green California attorney, go forth, do great things, change the world. It is it's a great profession. I still think it's an honorable profession. So just do the right things. Don't steal clients' money. Don't sleep with your clients, and always communicate with them. They should get a copy of every single piece of paper, or just about every single piece of paper you produce and that you receive in here. Let's see. I think about doing YouTube on the side, but I have a music channel, but they don't monetize. I have to make more than YouTubers shouldn't be doing. Yeah, it's tough. I mean, I'll be honest with you. I can make in a month, or I can make in one day what YouTube makes that we get paid here, bottom line. But I think the whole reason we started, why we continue to do this, is we want people to understand the law. We've had so many people that have said, Scott, you taught me the law. Scott, I normally never would have even listened to a criminal defense attorney, but you've changed my mind that people have a right to due process, the right to counsel. So that's why we do this. I mean, could I be doing other things? The lovely Miss Kristen is at home. I'm sure she would rather me be there than here. Miss Winnie, the bulldog, and for those of you who do not know, she has her own Instagram and TikTok channel, and you should go check it out because she's such a cute little dog. She is so cute. And so anyway, so that's why we do it. Hopefully we bring some education to people, explain things where people can truly understand the law better. I would love to interview Mark Means, but I don't think he's going to join us. But I guess we can always reach out. They have a gag order, so they can't really talk about the case. So maybe afterwards. Mama Pink, Scott, I know what mitigation is because of you. There you go. See? All right. We got to end it here tonight. For those of you who are Patreon members, Frank, the hardest working man in show business, will be sending out a link for you here in a few minutes. Take a quick break, and then we'll do our Patreon where you can call in, and we will ask the magic 8-ball the question of the evening that we all come up with. So thank you very much, and thanks for watching. Make sure you catch our video tomorrow, and if you haven't done so already, please join us as a Patreon here in about 10 minutes. Have a wonderful night. We'll see you tomorrow.